and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. My name is Anthony Sanders. I am the director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on September 7th, 2022. We're going to have an exciting podcast with a federal and a state case where we're going to talk a lot about remedies. You may have a right, but do you have a remedy? John Marshall once told us that you indeed do. And we're going to see how that's not always true, but sometimes it is. Joining me today are two Institute for Justice power attorneys, Anya Bidwell and Ben Field. Welcome back to both of you.
Hey.
Thank you.
Well, first of all, Anya is going to, while she's here, she might as well talk about when you can meet her in person if you happen to live in New York City. So, Anya, when's that going to happen?
That's going to happen on October 26th. It's a Wednesday. Doors open at 6:30 p.m. We got this very fancy venue called Mezzanine, and we're going to be all very fancily dressed. So
in the financial district, I believe. So all the Wall Street traders can come by and see you after they're done.
Yes, and we have three amazing guests. Maren Shah, she's a partner at Queen Emanuel. She also teaches at Stanford. We also have Professors Bruce Green and Alex Reinert. They all clerked for the Second Circuit. They also clerked for the United States Supreme Court, at least some of them. They argued amazing cases before the Second Circuit. So it's going to be really interesting. It's going to be Second Circuit heavy. And we're going to get some nice rumors in as well as discuss some cases.
Great. Well, you can sign up online. Make sure you RSVP. We have a link in the show notes if you want to come meet some folks from the Institute for Justice. But today you can listen to folks from the Institute for Justice talk about remedies. So, Anya, take it away in the 10th Circuit.
Yes, thanks, Anthony. This is a very interesting case, and I wanted to discuss it because it's, post Egbert versus Boulay, the United States Supreme Court case from the beginning of June of this year, when the Supreme Court basically said that we will allow a remedy directly under the Constitution in very, very few cases. So listeners understand we're talking about the Bivens remedy, right? So it's a damages remedy for when an individual federal official violates your constitutional rights. For a while there, we thought that this is a very broad remedy where as long as somebody violates, as long as federal official violates your constitutional rights, you can immediately open the courthouse door. But the United States Supreme Court has told us on several occasions that this is actually a very, very narrow remedy. And the last time it said so was this case, Egbert versus Boulay, where it was a Fourth Amendment and First Amendment claim against a CBP officer. And the Supreme Court essentially said that plaintiff is out of luck. And the plaintiff in that CBP case in Egbert might not be as sympathetic, but in this case, the 10th Circuit case, the facts are actually quite chilling. And the 10th Circuit, with both Democrat and Republican appointees, said that we really don't care about how chilling the facts are. There is no remedy because of this Egbert case, right? So the facts are basically this is a prisoner in federal prison. This guard went into his cell, which took him outside the view of security cameras. And once inside the cell, the federal guard assaulted this prisoner by, quote, slamming him on the floor, jumping on his back, and applying painful pressure with his knee. And then other officers falsely accused this prisoner of actually assaulting the prison guard himself. And so the prisoner brought pretty typical, excessive force claims. And in the olden days, chances are that, a district court and a federal court of appeals would have looked favorably upon those claims and allowed them, at the very least, allowed them to proceed against the federal defendant. We are not talking here about, remedy being ordered immediately. All we're talking about here is the ability to prove your case in court, to open the courthouse door in the beginning. And in this case, however, the panel is basically saying, we're not going to do that. We don't care how sympathetic the claims are. We're just not going to do that. Post Egbert versus Boulay, the court says, and I quote, "The Supreme Court's message could not be clearer. Lower courts expand Bivens' claims at their own peril. We heed the Supreme Court's warning and decline plaintiffs' invitation to curry the Supreme Court's disfavor." And it's a very short opinion. There is no dissent. You have W. Bush appointee, you have Reagan appointee, and you have Carter appointee. And the three of them just are not willing to go there at all. They say that post Egbert, this prisoner has no remedies whatsoever. They also say that post Egbert, you essentially have two ways how you can deny a remedy. The first way is whether a court is competent to authorize a damages action, not just against an individual defendant, but so the first way is really whether Congress is more competent to authorize a remedy or a court is more competent to authorize a remedy. And, the Supreme Court says the court is essentially almost never competent to authorize a remedy. And the second way is, whether there is an alternative remedy. And that's kind of a thing that I want Ben to talk more about when he talks about the Michigan case. Because here, the way they look at alternative remedies is not whether the plaintiff himself has alternative remedies, but whether, there is a deterrence for the future. So it's not necessarily about what happened in one particular case. It's whether there is a quote, means through which allegedly unconstitutional actions can be brought to the attention of the government body and prevented from recurring. And in this case, the court says, listen, there is a Bureau of Prisons Administrative Remedy Program. It's a regulatory scheme. And, maybe it won't provide a remedy to this particular prisoner in this particular time, but there is a chance, at least we know it's going to be brought to the attention of the Bureau of Prisons, and maybe in the future, it's not going to happen. And that is essentially enough to deny a remedy to this prisoner in this particular case. And that's kind of a really good example of how courts are looking at a federal remedy against federal officials post Egbert versus Boulay. So they really are looking at it as there is a general prohibition on remedy against federal officials. And because, as they say, Congress is essentially always better suited to provide a cause of action. So apparently it's up to Congress to tell us when we can sue and when we can't sue. So there's a general prohibition, and there could be very few situations where somehow court is better positioned than Congress. And really, I am yet to find a case where the court will say, no, you know what, we are better positioned to provide a remedy. So, Anthony, earlier you talked about where there is a right, there is a remedy. When it comes to federal courts against federal officials, this is a really good example where there is essentially no longer any remedy, period. And this case is a great demonstration of that.
One question about that here, I agree with everything you just explained, Anya, but this was also a suit against the United States itself. And I'm guessing it was under the Federal Tort Claims Act, but it seems like that wasn't appealed or something happened at the district court stage. Do we know what happened to that part of the case?
We don't know what happened to that part of the case, but you have a pro se litigant, essentially. So there have been a whole bunch of procedural issues down below to the point where the defendant, actually the individual defendant, because on appeal, the only question is the individual defendants and their liability. The individual defendants on appeal argued that you don't even have to address the Bivens thing here because the pro se complaint was so bad that they're just, the court had the option to throw out the case altogether and not even reach the question of Bivens post Egbert. But they specifically say we exercise our own discretion to address the merits of the issue here. And then they go on to provide a very banal, opinion on Egbert.
Well, because I say raise that because I would think a much more sympathetic way for the court to address this situation, rather than you can file a complaint that everyone knows probably won't get read, is that your suit against the actual government, not the official, you might get some money for, whatever how that actually works.
There's a case called Carlson versus Green, where the United States specifically said that the FTCA and the Bivens are not alternative remedies. They're complementary remedies, and they are not mutually exclusive. The Supreme Court likes to pretend that Carlson versus Green doesn't exist, but I think everybody kind of understands that there's still that case, and it's pretty explicit about FTCA remedies versus Bivens remedies and how they're not mutually exclusive. So courts, if they can kind of avoid discussing that, they generally just avoid discussing that and find something other than the FTCA to use as an alternative remedy.
But I should point out too that that the FTCA, if there's a violation of the Constitution, you don't use the FTCA. You use the FTCA for what we would call common law causes of action, like battery or what have you. So in that way, there are many cases where it isn't, well, we'll talk about with Ben's case, where it isn't a perfect substitute.
That's right. It's, sometimes you, of course, have like Fourth Amendment claims where there's a big overlap between common law torts and constitutional torts, but sometimes you don't have that.
Well, Ben, speaking of constitutions and common law torts, tell us what you think about this 10th Circuit case, but let's weave into what happened in Michigan, where there was a very different result.
Yeah. So there's essentially, I think, if you think of it, there are three different types of constitutional claims you might be bringing. You might be bringing federal constitutional claims against federal officials. And as that 10th Circuit case illustrates, that's virtually impossible now. You might be bringing federal constitutional claims against state officials. And fortunately, there's a statute that we've talked about a lot on Short Circuit called Section 1983 that lets you do that. It is still daunting. You have qualified immunity and all the other things we talk about, but at least you have a cause of action to get into court. And then there is, what if you want to bring a suit against a state official or a state agency under the state constitution? There are a handful of states that have a sort of 1983 analog, but it's pretty rare. And so the question is there some equivalent to Bivens at the state level? And it's state Supreme Courts that get to make that decision, which brings us to this case in Michigan called Bowserman versus the Unemployment Insurance Agency. And as you were alluding to, Anthony, this is a case that doesn't really have a private tort analog. It's not a battery or a false arrest or any of the things that we often think about Fourth Amendment style cases being. It's a due process claim. And, if the actual facts are pretty galling. So there are two named plaintiffs who are trying to represent a class of people who collected unemployment insurance in the state of Michigan. And then they were subjected to this very, we often, I think, use the word Kafkaesque, but it fits so often when you're dealing with state bureaucracies. So they collected their benefits. Everything was going fine. And then this automated state system determined that they were defrauding the state and didn't even necessarily tell them that they did. So for instance, if you stopped collecting your benefits and then didn't log into the unemployment insurance website anymore, you would never see the notice that the state had said that you were committing fraud. And so both the plaintiffs eventually, when they actually did get notice, they tried to challenge it, but ran into this wall. The automated system just trumped it. And you had the state garnishing their wages, garnishing their tax refunds and taking thousands of dollars from them. And then when the state actually did look at the evidence, said, oh, actually, there wasn't any fraud here whatsoever. But, at that point, the state gives you back the money, but you've gone through now 2 years of having to fight the state and worried that your next paycheck might just disappear. And so they want to go into court and say, we should be compensated for this violation of our due process rights. And so the question before the court was, there's no specific statute in Michigan that says you can sue for a due process violation. And so is there one directly under the Michigan Constitution or that's created by courts as a matter of common law to enforce the Michigan Constitution? And unlike Anya's case, this is one where the court did the right thing and said, absolutely, yes, there is. And I think that it went through many of the arguments that the anti-Bivens types of cases have addressed, and I think really demolished them in a very persuasive way. So the first thing that the majority said was that the recognition and redress of constitutional violations are quintessentially judicial functions required of us by the separation of powers. And I think that's a very important principle, that this isn't courts going out of their way to engage in lawmaking. Those constitutional rights are in the Michigan Constitution. In fact, the Declaration of Rights is the very first part of the Michigan Constitution, as it is in most states. And so all the courts are doing is saying, there are rights that are in the Constitution. We're going to make sure that there's a remedy for the violation of them. And then it goes on to explain history. And, there's not just, John Marshall was not picking a maxim out of thin air when he said that when there's a right, there's a remedy. The exact same thing is said in Federalist 15 by Alexander Hamilton. The court goes through history showing that at English common law, it was very common for courts to provide common law remedies when officials violated the basic rights of citizens.
Common law remedies.
Exactly. And I think another weird thing about this whole area is that in most of these cases, there's no statute that lets you get an injunction. But everybody agrees that obviously if the government is violating your rights, you can get an injunction. So there's this bizarre situation where everybody agrees that courts are allowed to invent a cause of action in order to stop the government from violating your rights in the future. But if the government has successfully already violated your rights, like in Anya's case, an official has beaten you up in violation of the Constitution, courts are often saying, well, if the government got away with it, then no remedy for you. And the Michigan Supreme Court says, no, damages are the most traditional remedy. And so there's no reason to distinguish between injunctive relief or money damages. And another important thing they say is often the critics of Bivens say, oh, well, courts are engaging in policy making. And I think the Michigan Supreme Court said quite powerfully, no, it's the opposite. What they said is, quote, this court should not be in the business of determining the, quote unquote, propriety of recognizing a constitutional damages claim. And so unlike the kind of analysis in that 10th Circuit case where the court is hemming and hawing about, oh, is it really our role to enforce this? The Michigan Supreme Court says, no, it's the opposite. Courts should, as a default, be enforcing constitutional rights. We didn't create the rights. They're in the Constitution. We're just providing a remedy for them. And if we start deciding, oh, is it appropriate for us to do this in this situation or not, that is policymaking. That is what is inappropriate. It's not policymaking to just look at the Constitution, say there's a right, and then to enforce it. And so at the end of the day, what the court held was, in Michigan now, there's just a strong default that unless the specific constitutional provision has specifically delegated the enforcement of the right to some other body like the legislature, and unless the legislature has actually created a remedy that would be sufficient and at least equal to the common law remedies that would be available, then the Michigan Supreme Court and the Michigan courts generally are going to enforce the Michigan Constitution and allow people to seek damages remedies if that's the most appropriate remedy in their specific case. And frankly, I'm not aware of any other court that has been this strident in saying constitutions mean something. Our state constitution is the supreme law next to the federal constitution, the supreme law in our state. And if a constitutional right is violated, we're going to enforce it. One potential caveat is this was a 4-3 decision, and there was a concurrence written by one of the justices in the majority. And I think she has some very good language in her opinion. For instance, she says that an untenable situation would arise if the state could violate an individual's fundamental inalienable rights without the individual having a legal pathway to an adequate remedy. Our fundamental and inalienable rights would hardly be fundamental at all without such a remedy. I agree with that 100%. That bolsters the majority position. But she caveats it in two ways that might be important in future cases. First, she says that I'm only going along with the majority insofar as we're talking about rights that are in the Declaration of Rights. So in her view, you can't sue for rights that are outside of the state equivalent of the Bill of Rights. Most claims are going to be under that, so I don't think that's a huge caveat, but it's one thing to keep in mind. And she also at least predicts that this is going to be, quote, relatively rare, because in her view, there often will be an alternative remedy. And I think that's an empirical question to be determined. I think that she might be a bit sanguine about that. But if the Michigan legislature is providing strong remedies for people, more power to them, and that's great. But to the extent they're not, it's good that the majority of the court is firmly on the side that the court will provide a remedy, just like courts have done at common law for centuries.
And this question of alternative remedies is fascinating, right? The majority kind of is pretty clear in the way they're defining alternative remedy. And they're basically saying, no, so there is this right that was violated. And an alternative remedy would be something that would specifically address that right and provide a sort of recompense for that injury. Justice Welch, in her concurrence, she's basically saying it doesn't necessarily mean that the plaintiff will be a whole, but she doesn't dispute this fundamental idea that no, alternative remedy means dealing with this particular right and that particular injury.
Absolutely.
And the way we see it in federal Bivens cases is that alternative remedy can be anything, right? It's just kind of the way this 10th Circuit case is looking at it, where, if there is some sort of a regulatory regime that would inform the Bureau of Prisons that there is a problem that they have on their hands, that
Let's
could be
you
enough.
send a postcard.
Yes, there's another case, Ahmed versus Waker from the 8th Circuit, where they said the Hatch Act, victims of trafficking, right? That could potentially be some sort of an alternative remedy in a situation involving a woman who was, jailed for 2 years for no reason because an agent lied and caused her to be incarcerated. So the way that the federal courts are interpreting alternative remedy is extremely broad. And the way the court is doing it here in the Michigan case is very targeted, very narrow, very much focusing on this particular injury and whether this particular person would be compensated for that particular injury.
Yeah, the specific language in the majority opinion is that the legislature's alternative must be at least as protective of a particular constitutional right as a judicially recognized cause of action and must include any remedy necessary to address the harm caused. And so obviously, in that 10th Circuit case, being assaulted in your prison cell, filing a grievance so that some other person isn't assaulted isn't providing you any remedy whatsoever.
Right. It's not an excuse. The way that the federal courts are looking at it is an excuse to deny a remedy. Here, it's like, no, it's actual, whether there's a right, there is a remedy. If there is an alternative remedy, they're just as good, fine. But if there isn't, then that's not good enough.
So this case is extremely fascinating and one of the most fascinating state constitutional law cases of the last couple of years. But I apologize. I may cause a little bit of a rankle among the panel with a couple observations that I had. So I agree with both of you that the end result is the way that it should be in with the majority opinion, that you should have a remedy for the violation of what happened to these people in this case under the state constitution. But I think this is an unusual case where even though I agree with what the majority said, I did find the dissent in the case really well done and fascinating.
A la Justice Scalia, right? He brought out his best Justice Scalia.
Sure, yeah, you could say that. So this is Justice Viviano's dissent, very long, poignant dissent. I thought that he actually got a little deeper into the, you might almost call the metaphysics of how this stuff works than the majority. Although I think the majority got to the right result. And the reason I say that is this whole right. We went into I say we, it was really John Ross and Anya. Went into the last season of Bound by Oath, our sister podcast, into a lot of this stuff. And we had a couple episodes about like, where do remedies come from? Like, what does it really mean to have a remedy under the Constitution versus a remedy at common law? And we keep throwing around common law. And for non-lawyers out there, that really means like someone causes like a real wrong to you, takes your stuff, beats you up, whatever it is, and then you have a cause of action against them to be compensated for that. So we went into all of the ins and outs of how that works, and one thing to take away from that on what happened with Bivens at the federal level is the federal courts used to just have regular causes of action at federal common law, because federal common law was the thing. It just kind of mirrored state law. So say you had to get into federal court, you had to have some kind of reason to be in federal court under the Constitution.
Diversity jurisdiction.
Like diversity jurisdiction, right? You're in different states, right, or some federal statute or something. But
federal question jurisdiction shows up after the Ku Klux Klan Act, Section 1983, right at that time.
Right. But there's still federal common law at that time. So then they get rid of federal common law of this thing called Erie. That would be it's a whole season of Bound by Oath that we won't get into in the 1930s. And then you're left with, there's a gap there for like doing the thing that you should just normally do, which is sue a federal official for a wrong. And so they come up with Bivens and say that, well, it's a violation of the federal Constitution. It's not just a tort. It's like a violation of the Constitution. It happens to be a government official. And so you should have a way and Congress has never bothered to pass a law saying you can do that like they did with 1983. And so you can get into court with that. Well, what Justice Viviano kind of gets into is that with the kind of the common law that you have in that where judges create remedies for a battery or a theft or something like that, it doesn't really map onto constitutional wrongs. So someone in the government violates your due process rights because, of course, the common law in England, they didn't have a written constitution. He kind of makes fun of the British Constitution at one time where he says it's an unwritten kind of hazy constitution. By the way, we're going to have an episode on the British Constitution in coming months, a little preview for you guys. But so how does that work? Now, the thing is, I think American jurisprudence has never really come to grips with this really deep question, which is how does the common law causes of action map onto the written constitutional order that we have, and how do they relate to each other? Because he says, look, under the written Constitution in Michigan, the legislature has this lawmaking power. And under the old system of Parliament, like judges made up cause of action, but Parliament could come along and change it. And here we have the legislature basically just hasn't done anything other than maybe sovereign immunity. And then you have these rights in the Constitution. So judges making up, I say making up, I'm trying not to be pejorative, they coming up with remedies for violation of those rights. That's not the same thing as coming up for a remedy with a violation of the common law, because that was just part of the common law. Now, I think those two things are much more similar than he's giving it credit to, but I kind of see where he's coming from there. And I think the majority glosses over that a little bit. Maybe they just don't think like that, that's angels dancing on a pin. And so we don't need to worry about it.
Yeah, I think that I agree that the majority doesn't. I agree with you. This area is somewhat under theorized because until really the 1950s or 60s, as you would learn from Bound by Oath, constitutional tort litigation didn't really exist. And so this is a relatively recent area of law, and state high courts in particular are only now really delving into it. But I think that the majority's basic point about a right having a remedy is responsive, and it turns what Justice Viviano is getting at on its head. Because so at common law, in the 18th century, where you have, judges and justices in England having to decide, well, what are the kinds of things that we're going to provide a remedy for? There isn't a lot of legislation as a backdrop for them to make decisions on. But we move into the United States with written constitutions. And now there is a body of law, of written law, that gives rights to people. And so the question for the court is not, is this kind of thing a right that you have, or is it not a right? Instead, you have the right. The question is just whether or not there's a remedy for it. And traditionally at common law, if you had a right, for instance, a right against being bodily assaulted or a right against being defrauded, then, you would go into court. You could pick which court you went to, whether it was a legal court or an equity court. But that the type of court you had a certain menu of remedies available, and if you could show that your rights were violated, then you would get the appropriate remedy for it. And so I think that all that the Michigan Supreme Court is doing is saying, look, there is a body of positive law out there that gives people rights, and so the question is just, do we have to wait for the legislature to create a cause of action in order to remedy that? And I think the majority is very poignant in saying, no, if you have to wait for the legislature, then the constitutional rights are essentially meaningless. You've essentially eviscerated the Constitution and gone back to the 18th century where Parliament is, supreme, because there is, if Parliament or the legislature can't be bound by the Constitution doesn't have any meaning.
And the Bill of Rights, right, is specifically an anti-majoritarian document, right? That's kind of the key to understand, too. The Bill of Rights is meant to protect against the rule of the majority, that the majority can't take away some of the rights that you that have pre-existed the government, right? And it is rather absurd to say that a majoritarian institution like Congress or like legislature is the one that would allow you to go into court to enforce your anti-majoritarian rights. That just completely clashes. And the other thing that I think is interesting is the discussion between the majority and the dissent of what is the role of the judiciary within the separation of powers, and how do you see that role in this particular situation? The majority is basically saying it is our duty within the separation of powers to provide a remedy, right? And the dissent is saying, no, the separation of powers is telling us to stay away and wait for legislature to provide the cause of action. And the majority, I think, is much more in tune with the foundations of this country in terms of the separation of powers principle, right? That famous case by Justice Story, the Apollon, where he talks about how it is supremely the function of the judiciary to see whether the wrong was committed and then order an appropriate remedy. It's not the function of the legislature, especially when it comes to providing you a permission slip to enforce anti-majoritarian rights.
Yeah, and they point to the majority points to the Michigan Constitution's grant of power to the Michigan Supreme Court and says that it has the judicial power of the state, and part of that judicial power traditionally is these creation of remedies, as you say.
And I think it's also telling that Justice Viviano and the kinds of jurists that he's channeling really lack the courage of their convictions. Because if they were serious and believed that you really do need a permission slip from the legislature to enforce your constitutional rights, they would say the same thing about injunctive relief. Yeah. Well, and the majority points that out.
The funny thing about that is, so I have actually had to litigate this question, so maybe it was more fresh on my mind than Justice Viviano. But usually you do actually have a statute to enforce injunctions and definitely declarations, declaratory judgments, and that's the UDJA, the Universal Declaratory Judgment Act, which most states have adopted, which gives you a cause of action to have a declaratory judgment about various things, but included in that is the constitutionality of an ordinance or a statute. And when he didn't say that, I thought, I don't know, maybe he had already written a very long dissent and he was a little exhausted and his clerks, had to go to dinner. And so they didn't put in the stuff about that. But that actually is true in most of the time, that you do have a statutory cause of action where you wouldn't. So, for example, I believe in Texas Supreme Court said there's kind of a waiver of sovereign immunity to go to court on questions of declarations and injunctions because of the UDJA, but there isn't for monetary damages. So I thought that was just something interesting he left on the table.
Nobody disputes, though, right, that you don't need that statute. It's nice to have, right? It's kind of like with Section 1983.
Well, I think some people do dispute that. I think some people do, but it is very accepted, though. Maybe it's the majority view is that you don't.
Right. And so, in fact, Justice Scalia wrote an opinion near the end of his life in a case called Armstrong, where in a very, very short paragraph, with just like one citation, he says, obviously, there's an equitable right to enjoin unconstitutional government action. Doesn't go any further, doesn't explain it. Obviously it wasn't about Bivens, so he doesn't have to explain how it's different from Bivens. But like the federal statute books lack any cause of action creating language for an injunction. And that's true in most states too. Even those with the Uniform Declaratory Judgment Act, they don't have necessarily a separate statute that creates a right to get an injunction. I think the language is declaratory judgment or other relief, which is always rolled because everyone always asks for both if you ask for an injunction. But yeah, those statutes are less than 100 years old because the declaratory judgment, I think, was an invention in the 1930s. And before that, there was, various mechanisms that courts of equity, the old chancellor in England, would provide that kind of relief.
But I want to bring us back to this sort of, and to finish on that note, so listeners kind of think about that. So back to this distinction between local and state officials and federal officials. So in this Michigan case, for example, if you are a Michigan official or if you are a local official within Michigan, you can be sued, or in this case, it's actually an agency too, right? The state of Michigan itself. You can be sued for violations of the Michigan Constitution or even the United States Constitution, right? You can be sued under Section 1983 in federal courts for violations of federal Constitution. You can be sued directly under Michigan Constitution. There are many different options to hold state and local officials to account. And as Ben mentioned earlier, you could run into qualified immunity issues, and that could be a big problem. However, it's a much better situation if you're a plaintiff than if you're a plaintiff against a federal defendant, because this implied right of action under Michigan Constitution are going to do you no good. You can't sue a federal official in state court because of the Westfall Act. And now, as you can see with this 10th Circuit decision, the federal courts are interpreting Bivens as essentially bad law and no longer providing any cause of action for violations of the Constitution under Bivens. So if somebody hurt you and they happen to be a federal official or they happen to be on a federal task force, you're pretty much out of luck. And those guys have absolute immunity. So that's kind of the big picture Eastern European pessimism for you.
We always love the Eastern European pessimism, Anya. I actually have an additional question, and this is maybe a way to bring back our report, 50 Shades of Governmental Immunity, or 50 Shades of Immunity, that we released earlier this year, and that Alex Reiner, who's going to be on Short Circuit Live next month, was a part of. And we did a special Short Circuit on, I think, back in February. We'll put a link to that episode up in the show notes. So what we talked about in that episode was there are some harms that are both constitutional and common law, you might say. So like a Fourth Amendment seizure, right? An officer grabs you, maybe breaks your arm, something like that, doesn't have probable cause to do so. That's a seizure, but it's also just an assault, an old-fashioned battery that you could sue for. This case, Ben, you said this case isn't really something you could sue for. I think partly that's true, but partly the people who are seizing these tax returns or demanding, saying you have been stealing unemployment benefits. It seems like you could bring some kind of maybe, I don't know, negligence claim, or like they committed extortion or some kind of theft is a crime, but some kind of cause of action you'd have for, taking your stuff essentially. And then eventually they got it back, but there's, these people were probably out. I don't know. They couldn't make rent a few months, or they're out some kind of damages, maybe pain and suffering for what happened to them. So is there a way that what happened to these people in this case could be seen to be a common law cause of action? And I think it's interesting maybe just to think about, can that be seen as then therefore more parallel to an old-fashioned common law action, and maybe there's more justification for the creation of this cause of action? But also, could they have just sued, forget the state constitution? Could they have just had that as a lawsuit? But if they did that, are there state immunities in their way where they wouldn't get the relief? I don't know. I'm suspecting maybe there is, and that's why this lawsuit was structured that way. But I wonder if if that's part of the story too.
So I think that this raises a couple interesting points. So first, I don't know the details of Michigan, but most states have a statute that waives sovereign immunity, and it has built into it a lot of rules and exceptions, which often would block those kinds of suits.
It's like we waive it, but not really.
Right. But I think that your question gets to a sort of deeper and more fundamental point, which is, so it's conceivable. So you could say this was negligence, or this was the tort of conversion, which is when you take somebody's property illicitly. But that's not, it's not, typically when you think of conversion, it's, I entrusted my money to my cousin and then he ran away with it. That's conversion. It's very straightforward. Here, it's not really. If the government had been right that these plaintiffs were committing fraud, it would have been fine for them to do it, to take the money. And if they gave them due process and these plaintiffs just never showed up to prove that they weren't committing fraud, then the government probably wouldn't be violated. We probably wouldn't be committing a wrong either. It really is the lack of process that's the harm that was suffered. And you can try to shoehorn that in to private torts. But if we agree that at the end of the day, you should have a remedy when your due process rights are violated, it seems unusual to me that we would demand it. And you might be able to shoehorn this particular case in, but that's not going to be true for lots of ones. So the classic example are free speech rights. Other people don't have any obligation to respect your speech. They're allowed to say, you're an idiot, I'm not listening to you, and I'm not going to be your friend if you keep talking about, politics that I don't like. But the government doesn't have that ability. The government is restricted in what it can do to you. And so there just is never going to be a private tort for very fundamental rights like free exercise of religion or free speech. And it just doesn't make sense to try to force all of these issues into common law private torts that happen between individual people, because that relationship is very different from the relationship between a person and a government. And the majority opinion gets into that.
And that brings us full circle to that episode, Anthony, with Alex Raynard, where he discusses this and also how it is a very particular harm when it's government that's doing it to you than private individuals who are doing that to you. And that's why the constitutional violation is so different from common law violation, even if you have a big overlap between the two causes of action. Yeah. That there's something special and particularly pernicious about the government doing it.
I think that's very well said by both of you. And I agree that free speech is the best example. If, say, you have a sign advertising your store and the government forces you to take it down, and therefore you can't sell your stuff, I mean, that's a classic economic damages kind of situation, but there's no tort that you'd be able to bring for that, other than it violated the Constitution, that they discriminated against your speech. And there has to be, at the end of the day, in my mind, again, going back to the majority and why I think they came to the right result, at the end of the day, there has to be something about it being the fundamental law of your jurisdiction that the government itself can't act in this way. And yet you wouldn't have a cause of action because the majoritarian legislature hasn't bothered to give it to you. But you could if, it was just an old-fashioned common law right that was never put into any kind of fundamental law between private parties. It seems like that's just backward, and there has to be a way for the judiciary to right that wrong.
Right. And under the dissent view, it seems to me it would be perfectly acceptable for the legislature to pass a law that says you may not criticize your legislator and you have no cause of action to enforce your constitutional rights to challenge this law. And that just can't be right. If that's right, constitutions are meaningless.
Very well said. Well, we'll leave it there. And thank you both for this tour through remedies and rights and everything in between. We'll keep our eyes on how these issues unfold in the coming months and years.
Keep an eye on Nevada, right?
That's right. Nevada is
the
pending.
next. Yes, there is a pending case, and Ben argued it as an amicus about implied rights of action under Nevada Constitution. Ben, before we go, can you just spend 1 second talking about it? And so our listeners keep an eye on it. Nevada is next after Michigan.
Yes, so Nevada is considering this very question. It's in the specific context of due process rights, just like Michigan, and the rights against Nevada's Fourth Amendment analog. But it's answering just the broader question of when can you sue directly under the Nevada Constitution. And Anya was there with me in Carson City earlier this year. I got to present an argument asking them to essentially take the tack that Michigan has taken. And we obviously, the moment this Michigan case came out, we submitted it as supplemental authority. And we hope that Nevada will be the next state to join this chorus of actually enforcing its Constitution.
And on that bombshell news and cliffhanger, we're going to end it there. Thank you, Anya. Thank you, Ben. Appreciate you coming on. We'll keep our eyes on Nevada. And in the meantime, we're going to ask everyone to get engaged.